Thanks, Lee. Thanks for having me today. Thanks, everyone, for tuning in. I will warn you that this has no element of entertainment. This presentation, this PowerPoint I have done, it is purely information-based. I know that people who are tuning in on a Wednesday morning probably want the information, and that's what I will be focusing on today. So apologies for the lack of jokes or pictures. So a little bit about me to start off. Became a solicitor in 2014, got a job with a wills and estates firm at that time, and have only ever done wills and estates law since that time. So that's what I like doing, and that's what I've continued to do up until this point. Luckily for me, you can make a career out of wills and estates law because there is a fair amount of content in it. Unfortunately, there is a system we have in Queensland where you can contest estates, and I am not a big fan of that system. So I started my own firm 3 years ago to get away from that area and to focus more on planning and protecting your assets. So that's what I started Henry Lawyers, and that's what we do. We try to protect the money that you have made throughout your life so that it goes to the people that you actually want to give it to. So what are we going to talk about today? So we're going to give a broad overview of estate planning, all the issues that you should know, what happens if you don't have a will, what happens if you do have a will, talk about probate. You've probably heard of that term, might not know what it means. Real estate, so what happens to your property when you pass, what happens to superannuation. Touch on family provision applications, so that's that issue of the contesting of the estates, and testamentary trusts and enduring powers of attorney. So we'll pretty much give you a good overview of everything you should know if you don't have a will, and even if you do have a will, other things you might not have thought of. So biggest question on most people's minds who don't have a will is what happens to your assets if you die without a will. So this is called intestacy. So someone who has died without a will is called an intestate, and their estate is distributed in accordance with the rules of intestacy. So the first thing that needs to happen is an administrator needs to be appointed to be able to deal with your estate. Because if you don't have a will, you don't have an executor. And if you don't have an executor, you don't have anyone that has authority to deal with your assets. So an application to the Supreme Court needs to be made by a family member or next of kin or a friend. And that is not a very difficult application to make, but it is a burden upon someone who does need to do that immediately in able to deal with your assets. Once that application is done and an administrator is appointed, that administrator will need to gather all your assets, pay out any tax or any liabilities or any debt, and then distribute your estate in accordance with these rules of intestacy. So these are rules that have been given by our government, and they believe this is the best way that your estate should be distributed, depending on your family circumstances. So if you have a spouse and no children, your spouse will receive your entire estate, and that includes a de facto spouse, and that's someone that you have been living with for a continuous period for 2 years prior to your death. If you have a spouse and one child, then your spouse receives the first $150,000 from your estate, anything in your household items that belong to you, and then half of your residue, which is the name that we give to your estate after all of your debts and liabilities have been paid. So your one child then receives the other half of your residue. If that child's under 18, their share of your residue needs to be held on trust by your administrator until they attain the age of 18. So you can probably see how that could cause problems straight away. If you have a spouse and one child, your one child is going to receive half of your estate essentially. And that can cause problems because most of the time you're going to want your spouse, which is most of the time the father or mother of that child, to receive your entire estate so that they can have free access to the money. If you have a spouse and more than one child, it becomes even more problematic because your spouse only receives a third of your residue. And then your remaining your children receive the remaining 2/3. So you can see how the government's trying to make this system work so that your children aren't disadvantaged, but in many ways, it can very much disadvantage your spouse because your children end up getting quite a large portion of your estate. If you have no spouse and your children share equally in your entire estate, and that normally works out okay. If you have no spouse and no children, it will go to your parents. If you don't have any living parents, it will go to your siblings, and then down the line amongst other family members. It's often something that people are afraid of, is that their money's going to go to the government if they die without a will. That is not something that happens very often. You would need to have essentially no family members for that to happen. So we rarely see that in practice.
So Tim, who does all the sort of obviously got the determinations here, but who has to do all the work to find who it eventually goes to? Is it the administrator that has to provide it all information?
Yeah. So if there's no actual family member, then the public trustee would step in to become the administrator. But someone would need to inform the public trustee that that needed to be done. Because if there was no one to receive any benefit from the estate, then it would just sit there for quite a long time. So if you do not have any family members or next of kin, then getting a will would be necessary unless you want the government to be very heavily involved and receive the money.
And does the government take any money out of it for the estate?
Yeah, of course. Yeah. Yeah. So if you don't have any family members, the government will receive your entire estate if you don't have a will. If you don't have an executor and the government needs to step in to become your administrator, they will charge your estate based on the work that they do. So a lot of people... Is
that the public trustee?
That's the public trustee, yeah. And a lot of people may have heard recently the public trustee had been under a fair bit of heat for mismanaging funds, essentially, and being a bit dodgy with the way they hold funds. A trap ball that a lot of people do fall into is appointing the public trustee as their executor when they get a will done by the public trustee, because the public trustee offer free wills, and they often say to the people that they are doing wills for, why don't you appoint us as your executor so that you don't need to worry your loved ones with the job. And that's just essentially giving the public trustee free money to do most of the time something that someone else could have done for free. So the public trustee are a little bit sneaky with their appointment of themselves as your executor if you get a will done by them. So if you do go down that path, be careful with that.
Yep.
So that's what happens to your assets. What happens to your children if you have any minor children, so children under the age of 18? So if you don't have a will, then you haven't appointed a guardian for your children. So if you die and you leave behind one of their biological parents, then that parent will become their sole guardian. If you die leaving no biological parent of your children, then there will be no legal guardian for that child, meaning that someone in your family would need to apply to become that child's guardian. And as you can imagine, if there are two sides of a family who think that they would be the better guardian, that application to court can get very messy and costly because you have opposing applications. So those are the main three reasons to get a will. The problems that if you don't have a will are is you have no say in who is controlling your assets, no say in how your estate's assets are distributed, and no say in who looks after your children. So that's what happens if you don't have a will. Talk briefly about what happens if you do have a will, because I'm sure that most of the people watching today are responsible and have already sorted out a will, especially if they are clients of Lee, and I'm sure he's told them to do that many times in the past. So what happens when you have a will? So you have appointed an executor, then that person will have authority to deal with your estate, so your assets. Now, the job of executor is relatively time-consuming and stressful and difficult. So it is something that you want to give to someone who is benefiting from your estate where you can. So if you have it in your will at the moment that your sibling or friend is your executor, but your kids are over the age of 23 or 25 and they're probably capable of doing it themselves, I would suggest amending that so that that person isn't burdened by the role of executor, because it is not a very nice job to do. I've never met anyone that was happy to become an executor. because it is quite a large job and it can get very stressful. What your executor actually does, so they find the will, they tell the beneficiaries that they are entitled to something from your estate. They apply to the court for the grant of probate, which we'll touch on a bit later. They maintain and protect your assets. So the most important thing there is making sure that your assets are insured, because your executor becomes liable for anything that is in your estate after you have died. So if there is a property in your estate, for instance, and your executor doesn't maintain the insurance on that property, and then that property burns down, then your executor becomes liable for that property and will need to essentially pay their own money back into the estate for any losses. So it is quite a burden, as I said. Arrange for the disposal of your body. So if you put something into your will, your executor can follow those directions. If you put nothing in your will, or you don't have a will, then your executor administrator will be the person who will decide how your body is disposed of and what sort of funeral arrangements that you do have. And lastly,
sorry, Tim, you've got a comment there saying apply to the Supreme Court of Queensland. I'm assuming that if you're based in Victoria or New South Wales, that you would apply to the Supreme Court of that jurisdiction.
Yeah, that's right. So each state's quite different with their succession laws, their wills and estates laws. They're all governed by separate state legislation. The probate process is definitely different in other states as well. So New South Wales has a different requirement to get probate. Victoria has a different requirement. So each state, essentially, you should get probate for any assets in that state if you have major assets.
So,
Otherwise,
sorry, go on.
Otherwise, you can get probate in Queensland and then get it resealed in other states if need be. So that's a process of giving the Queensland probate to the other courts of the other jurisdictions and getting it sort of reapproved.
Which so is all based where you all based where you live,
where your assets are.
So if you've got assets in New South Wales and Victoria, and let's say you live in Queensland, would you get your will done in Queensland, or how does that work?
It would be best to get your will done where the majority of your assets are.
Right.
But essentially, your Queensland will cover all of your Australian assets. But if you have assets, the majority of your assets in another state, then it would be best to speak to someone from that state who does wills and estates law, because they would be better equipped to deal with your issues, because each state has their own issues and things to think about that do differ.
So you recommend if you're going to get your wills and your estate planning done, you get it done based on a lawyer based in that state?
Yes, definitely. That would be my recommendation.
Yep, cool.
And lastly there, defend your will. So if someone makes an application against your estate because they feel they should have received something from your estate, then your executor is the person that defends it. So they are the person who has to look out for the best interest of your beneficiaries. So you can have up to 4 executors at any given time, but they do have to act jointly. So there's no majority rules with executors. They do all have to act unanimously. So often having 4 is quite problematic, and from a practicality point of view, not a good idea. And they all have to sign paperwork as well. So normally I recommend 1 or 2 executors. I like the idea of having 1 if you trust that person, because it does make their life a lot easier. But if you do want to have both sides of your family represented, for instance, then you can have 2, but just keep in mind that they will need to act unanimously, which means that you want to make sure that they get on at least some for the purposes of administering your estate. Your executor is not required to accept their appointment, so it is very important to make sure you have substitutes. So if your first executor can't act or chooses not to, you have someone that can step in after them. And it's important to make sure your executor knows that you've appointed them, because if they don't know, then they're not going to know to locate your will after you've died, and they're not going to know who to contact.
Two questions I've got there.
Yep.
You talked about obviously naming your executor. So one is, where we recommend storing the will for the executor to obviously go find the will? That's my first question.
Yep.
What do you recommend?
So most of the time, most of my clients store their wills with me in my safe custody. So we have fireproof safes that keep them safe, and then you know where they are, and it's not a burden on you if you lose them, because a lost will results in a very costly application for probate after you've died, and is not always accepted either. So a lost will is definitely not a good idea. Some people choose to keep them themselves. If you do that, I do recommend that you keep them in a safe of some kind as well. What I normally do is give a signed copy of the wills to my clients electronically or in paper form, and then I tell them to keep that in a place where it will be able to be found by their family members. But it is mostly important that you let your executors and your family members know that you've done a will, that it's being held by this law firm, that you give that law firm's details to those people so that upon your death, they can be contacted to obtain the original will, because you do need the original will at the end of the day for most things.
And secondly, if you're someone that struggles to find maybe someone to appoint as an executor, like, who do you recommend to kind of, appoint? Is there professional services? Obviously, you mentioned the public trustee, but
yeah,
someone that, or a service that you could appoint as an executive if you really struggle to find someone to be.
Yeah, that's right. So yeah, there is the public trustee is an option, but as I said earlier, that's less popular these days, and in my opinion, I wouldn't go with them. There are professional trustee services. So there's a place called Australian Executor Trustees, and they offer professional trusteeship. So they take on the role and then they charge your estate accordingly. Frankly, they're pretty expensive. You can appoint your solicitor directly, and if you appoint your solicitor directly, then they will more than likely charge you based on the Supreme Court scale of costs, which is a court-appointed scale of costs that the court believes is reasonable, and then your fees will be assessed. That solicitor's fees will be assessed when they administer your estate. So that normally works out to be pretty reasonable. But like I said earlier, if you can appoint someone who is benefiting from your estate, that makes the most sense, because they're going to receive a benefit for the job they've done. Appointing someone who isn't benefiting from your estate is often quite harsh, because this is quite a big job.
Cool.
And then your executor must distribute your estate in accordance with your will. So your executor can't change your will. They have discretion about how your assets are dealt with. So if you have property, for instance, they decide how to sell it, what real estate agent to use, when to sell it, and what price to get for it. But they can't say this beneficiary gets less than that beneficiary. So their discretion is limited to how they deal with the assets, which in some cases can be a fair bit of discretion. But don't worry, they don't have the power to change your will. So what is your estate? Your estate is essentially the name that we give to your assets after you have died, and it includes anything that was solely owned by you, essentially. So after your estate has been collected, your executor will need to pay off your debts first. So that your debts need to be paid initially before anything is distributed. They also need to sort out your tax. It's a good idea to get that done before you distribute your estate as well. And then you can name specific gifts in your will if you like. So you could give certain assets like jewelry or paintings or even property or houses to particular people. And if you do that, then those gifts will get paid before you distribute the estate. And then everything that's left in your estate after all your debts and specific gifts have been paid is called your residue. So residue essentially just means whatever's left over, and that will be distributed to your beneficiaries or beneficiary in shares or percentages. But when you're getting down to the residue of your estate, it's most of the time best to do it as fractions or percentages as opposed to giving specific gifts, because you do need to get rid of your entire estate to make your will valid. Otherwise, you might fall back into those rules of intestacy, which we discussed earlier. So what is probate? So probate is defined as the official proving of a will. And what that means is the Supreme Court has had a look at your will and determined that it is final and valid. So the reason that most people need probate these days is that any banks or retirement villages that hold refundable deposits, or any sort of financial institution that's holding an investment, require probate as protection. So essentially, if you're an executor of an estate and you have a copy or the original will, if you go to a bank and try to get the deceased person's $50,000 out, the bank won't accept that. They won't accept just a will that is written and signed that appoints you as executor, because they don't trust that you haven't essentially forged that. So probate is the way that the institutions cover themselves. So if they know that the Supreme Court has said that this is okay, then they're happy to pay it to the person named on probate, which is your executor. And it's also protection for your executor. So if your executor has probate and then later on it's discovered that there was another will, or the will that was done was invalid, then your executor can rely on the Supreme Court's approval to say, well, I've done my job properly because I got probate. So at the end of the day, probate is red tape. There is a fair amount of red tape involved in it, and it is a process, an administration process, but it is recommended in most estates these days, because if you have over 30K, most of the time you're going to need it. And like I said earlier, probate will differ from state to state. So what happens to your real property when you die? So your real estate. So real property is often one of your major assets. So it's very important to make sure that you know what will happen to it when you pass away. And in Queensland, at least, there's two main ways to own property with another person. First one is called joint tenants, and that means that you each own the property equally, and that upon one of your deaths, the other one will automatically become the sole owner of that property. That's the most common way that couples own property in Queensland anyway. And then the second way to own property is as tenants in common. So this means that you each own a separate share of the property, and it can be 50%, can be 30%, can be 70%, depending on the situation. And your share in the property will pass through your estate upon your death. So the big difference there is, if you own your property as joint tenants, then it doesn't matter what your will says about that property. It will automatically go to the other owner of that property. But if you own your property as tenants in common, then your will does matter. And the other thing that's important about this differentiation is that if you own your property as joint tenants, it won't become an estate asset. So if it's not an estate asset, it won't be subject to any claims or creditors that are going against your estate. But if you own your property as tenants in common, then your share will become an estate asset. So it will be subject to a claim against your estate. So
the tenants in common would probably be quite common, I guess, with blended families. Is that correct?
That's right. That's exactly right. But often that's not a good idea, because sure, you might want to have your share of the property separate to the other owner so that it goes into your estate. But often with blended families, the ability for someone to contest your estate is a lot higher, because you have people children from a previous marriage, for instance, that may want to contest your estate. So having your property owned as tenants in common means your property will go through your estate and will become subject to that claim. So depending on the situation, if you have a second marriage, for instance, and you are happy for your property to go to your spouse, then it would be best to have your property owned as joint tenants for that circumstance.
So how would, I guess, in that situation, I've got a question about blended families, but if you got to, for example, that situation where property, how would you want to, I guess, look after, what provision would you do to look after, say, the kids?
So looking after the kids as opposed to your next spouse.
So, say for example, like you talked about the having in joint tenants. So let's say you've got a $500,000 property. Oh, sorry, $1 million property, and it's 500 grand each. You want that 500 grand to effectively go to your kids,
Yeah.
right? If something does happen to you, how would you kind of recommend in that situation for the property to? Well, you can't; it's too hard. Other than probably insurances, right?
Yeah. So the property, your share of the property will pass through your estate. So you can put it in your will that share of the property goes to the children, but there would be nothing stopping your new spouse from making a claim against your will, saying that that spouse should receive that share of the property. So that's not a very effective way to do it if you are concerned that a claim could be made against your estate. What you can do is hold the property as tenants in common and then own your share as joint tenants with other people. So you could have 50% owned by your spouse, 50% owned by you. Your 50% is actually held as joint tenants with your children. And then your 50% would go directly to your children upon your death. Oh. But doing that is going to incur stamp duty, and there's going to be other financial consequences involved. Most of the time, that's not going to be worth it, depending on the situation and the size of the property, I suppose. So moving on to superannuation. So it's very important to note superannuation is not an estate asset. It's not actually really even your asset. It's held on trust for your benefit. And then upon your death, it's up to the trustee of the superannuation fund to decide how to pay it. So the trustee of the fund has discretion to pay it to a spouse, a child, or a dependent. And dependents fairly broadly defined for superannuation, essentially anyone that is dependent on you at the time of your death or living with you at the time of your death. So what you do to take away that discretion, I'm sure Lee has covered this before, it's a binding death benefit nomination. So it's a rather simple form that you can print out and get signed witnessed by two people. And it essentially forces the trustee of the super fund to pay your super to the person you have nominated, provided they are a spouse, child, or dependent. I'm sure that a lot of the funds that Lee deals with are non-lapsing because they're the better ones to deal with. But some of the major, bigger funds like Q Super and Australian Retirement Trust and Australian Super, they all do lapse every 3 years. So if you do a binding death benefit nomination, you do have to keep in mind that it will lapse in 3 years, and you do have to renew it to make sure that your super is still paid in accordance with your wishes.
Yeah, so we've got a number of clients that have got either self-managed super funds. So in the trust deed of the self-managed super fund, it will stipulate whether there is non-lapsing binding death nominations, which all our trust deeds generally do have. So once you get your nomination in place, then unless there's been a change in circumstances, you don't need to update it every 3 years. And other super funds that we generally utilize, if we utilize, the non-industry super funds, they've generally got those non-lapsing death benefit nominations as well. And just a couple of things I'll just touch on as well. So there is potential. This is probably the only I would classify as death tax, because there's no death tax in Australia, correct?
Yeah.
So super is potential. There is potential tax implications. So if you nominate your spouse or a dependent, then there's potentially no tax. The only time that there is tax is generally if you nominate your child who is over the age of 18. Now, they could be taxed anywhere between 15% up to 32%, and depending on if there is actually insurances inside your superannuation fund. So if you wanted to nominate, for example, let's say your parents, you can't nominate them directly. You'd actually have to go through your legal personal representative, which is effectively your will, to then eventually pass it on to your parents, for example. So there's only certain people that you can nominate, and there's basically 5 options. So it's your spouse, your kids, effectively, someone who's a financial dependent, an interdependent relationship, and then finally your legal personal representative, which is then effectively distributed in accordance with your estate. So again, something you need to consider: is there tax implications depending on who you nominate, and what may those tax implications be depending on the makeup of your superannuation?
Yeah, that's right, Lee. And some clients I find have their super going directly to their children, even though their children are over 18, just because they want to give their children something upon their death, as opposed to everything going to their spouse. But as you would know, most of the time that's going to be taxed at quite a high rate, and you got to wonder whether or not it's going to be worth that, or you just make your kids wait until you both died until you give them their share.
That's how we generally structure it. Is just straight, spouses get the benefits, and then after that, well, then it's, I know it'd be good to get the money out of super before you pass away, but trying to time that's just almost impossible. So
that's right. Yeah. Best thing you can do is spend your money at the end of the day. When should you update your will? So generally, I tell my clients to not update, but review your will every 3 to 5 years. So have a look at it, see if it's still relevant, see if it's still valid. Reasons to change your will would be if an executor dies before you and you don't have sufficient substitutes in place. If a beneficiary dies before you and you don't have substitute beneficiaries in place, it definitely would be a time to renew your will as well. Keep in mind, if you leave a gift to a child and that child predeceases you, there's an automatic rule in our system, in Queensland anyway, that says that your children's children will receive their benefit. So if you don't want that to happen, you need to actually specify in the will that it would happen in some other way. If a specific gift has been given in your will and you have sold that gift or given it away prior to your death, then that gift will fail. So there will be no replacement gift given to that beneficiary. It will simply fail, and then your estate will be distributed in accordance with your distribution of residue, which you put later on in the will. So if you do have a specific gift and then get rid of it, it makes sense to renew your will at that point as well. And very important to note that marriage revokes your will unless you have done your will in contemplation of that marriage and the marriage is specified in the will to that spouse. Carrying on from marriage, separation from a spouse doesn't revoke your will. So if you separate from your spouse, it's going to be very important to update your will at that point, because more than likely you have given a great deal of your estate to that person. So if you don't want that to continue happening, it's very important to update your will at that point. A spouse is a de facto partner, so that's a person that you've been living with for 2 years prior to your death. Once you separate from a de facto relationship, that person will no longer be your spouse, but if they are named in your will, they still will receive whatever that you have given them in your will. Why that term spouse is important is because your spouse, if you don't have a will be the person who can most likely be your administrator, so the first person in line to be the person that controls your estate, and they're also more than likely going to be the majority beneficiary of your estate. And finally, they're going to be the person with the best claim against your estate if they feel they have been hard done by. So very important to keep in mind that just because you've separated from a husband or wife, you are still spouses. It's only upon divorce that you stop being spouses in terms of estate law. And the divorce will actually invalidate that spouse's name from your will. So they cut that spouse's name from your will. So most of the time, you don't need to do a new will after divorce. It's more important to get it done after you separate. So following on a bit from what we mentioned there about your spouse being able to contest your estate, who else can contest your estate? So the process is called a family provision application, and it's essentially an application to the Supreme Court or the District Court to say that you haven't received enough money, you haven't been provided adequate provision, they call it, from your estate, and you feel like you should because you were in some way dependent or at least related to the deceased person. So the following persons are eligible. So your spouse. So with most of these issues, your spouse includes a de facto person as long as you've been together for 2 years prior to your death, and that's on a continual basis. And then your ex-spouses can also apply to receive further provision from your estate, but only if they were receiving spousal maintenance at the time of your death. That's not something we see very often these days. Spousal maintenance isn't very popular anymore. And child support does not count as spousal maintenance, which is important to note. Next group of people that can contest your estate are your children. Very important to note that stepchildren are included in that definition. And stepchildren is any child of your spouse. So if you have, let's say you have a de facto partner, you've been living with them for 2 years, and then you pass away, that person's children will be eligible to make a claim against your estate. So no matter what relationship you had with them, they are going to be eligible applicants. The less relationship you did have, then the less likely they're going to be very successful, but they will always have the ability to make the claim, and that's going to frustrate your estate and more than likely result in some sort of settlement to that person. Because most of these matters don't go all the way to court. They settle earlier than court, which can often result in people who probably wouldn't have done very well in court getting something from your estate through a settlement, because your executors obviously don't want to go to court and expend the extreme costs of court that would then be taken from your estate and then taken from the beneficiaries you wanted to benefit. And then lastly, the group is dependents, but this is very narrowly defined for contesting purposes. It means any person that is dependent on you at the time of your death financially, but it must be either your parents, the parent of a surviving child of yours who is under 18, or a person under the age of 18. So, for example, a sibling cannot contest your estate even if they were dependent on you. It would have to be a parent or an ex-partner because they were the parent of your young child, or a child, essentially.
Got a question, Tim. Just in regards to contesting the will.
Yep.
I assume that you deal with blended families all the time. But I guess what kind of strategies would you sort of put in place to help sort of say, hey, look, well, this might help minimize contesting the will, obviously provisions and stuff like that. But is there any sort of fail-safe ways or things that you recommend?
I'll jump to the next slide because that covers that. No, there's no fail-safe. You cannot prevent a family provision application being made. So if you have eligible applicants, if you have stepchildren, for instance, or you have your own children, and you give it everything to your new spouse, they will always be eligible to make a claim against your estate. So there's no way to stop them upon your death from telling your executor they're making a claim, and then more than likely that will be settled just to keep it away from court. What you can do is minimise your estate. And this is the advice we give most people who are in situations where they are concerned that one of their children will make a claim against their estate, for instance. So essentially what we are doing is we're making sure that there's nothing in your estate, so it's not worth that person making a claim against it. And the way we do that is we hold your assets jointly with the people that you want to benefit. So if it's a spouse, for instance, you own your property as joint tenants, so it goes directly to that person upon your death. If it's a bank account owned in joint names with both of you on the title of the bank account, then that will go directly to the survivor of you as well. If you own a car together, then that will go directly to the survivor. Super, we ensure that you have your binding death benefit nominations going to the people that you want it to go to as opposed to your estate. But essentially, that's all you can do. You can't do a great deal more to prevent a family provision application from being successful other than getting rid of what would be in your estate. Problem with those mechanisms, especially holding the property in joint names, joint tenants, is that you are more than likely going to incur stamp duty unless you've already set it up. So if you come to me and you have a house in your sole name and you want everything to go to your spouse and you're worried about your kids claiming against your estate, if your spouse is living in the house and you are actual spouses, then you will more than likely avoid stamp duty. But if it's an investment property, then you're not going to avoid stamp duty. If you want to make a child a joint tenant, you're not going to avoid stamp duty. So there are costs involved with the mechanisms that we try to make sure that your estate is reduced. And there's no real easy way to do it, to be honest. What you can do if you think all of that is going to be too costly and too difficult, you can do a thing called a statutory declaration, which essentially runs through why you're not giving that person any money and the reasons for not doing it. And you go through whether or not they were dependent on you and sort of when the last time you saw them, for instance, if they're estranged. What that document does is it gives evidence to the court if they do make an application, or to the people involved in the settlement of their application, just to show your side of the story. Because what can happen with these sorts of applications is the person who's trying to get money from your estate can lie, obviously. So they can say that they were getting cash from you, so that it's untraceable. They could say that, oh, my dad gave me $100 every week in cash. And if they would do that, then they're establishing dependency. And if they're establishing dependency, they're going to be more likely to be successful in their claim. So why the statutory declaration is important, it's to make sure that your side of the story is told and you are showing that this person is not dependent on you and there's no reason why you have an obligation to give them anything from your estate. But it is a case-by-case basis. There is no cover-all for these situations. You really need to consider what would work for you and whether or not it's going to be worth the costs. I'll just go back to the slide before Lee asked that question. What is considered by the court in a family division application? The most important thing that needs to be established by the person making the claim is financial need. So if they're very well off, they're more than likely not going to get anything. If they are quite poorly, then they will more than likely receive something. So that's the bottom line. If a dependent has financial need, the court considers that you should have given them something most of the time. It will depend on the size of your estate, the relationship you have with that person. If they were really awful to you, for instance, and the executor can prove that, then that will probably support a claim against them. But in practice, if a claim is made, it's normally settled and money will normally go to that person. So unless you can make sure you have nothing in your estate to make the claim not worth it, then yeah, there's not much you can do.
Do you have sort of, I guess, guides around, let's say, for example, you wanted to potentially not so much exclude someone, but give someone in your estate, like, for example, a child that maybe you don't have a good relationship with, I guess, as little as possible because, you don't have a connection with them. How do you kind of like a provision enough to hopefully that, if they do want to contest the will, that maybe they don't get probably more than they should be entitled to?
Yeah, that's right. So that's a tough one. Most of the time, the court is going to consider that children should be equally provided for. So let's say if you have $1 million estate, for instance, and you were giving $100K to one child and the other $450 to the other two, or the other two children, then that's probably not going to be enough. The court's still probably going to give that child more money. 200K, probably getting closer to the mark, but at the end of the day, it's going to be a case-by-case basis. It's going to be based on these considerations that the court will go through to determine whether or not that child should have received more money. So often giving a child a token amount isn't helpful. It needs to be something substantial so that you prevent them from making a claim, because if you give them $50,000 from a $1 million estate, it's just not going to. It will show that you haven't forgotten them at least, but you're better off doing a stat deck and just giving them nothing, in my opinion, because if that's what you want to do, then that's what you should be able to do. And I think our system is flawed in the way that it allows children to make claims against their parents' estate who don't want to give them anything. And I want to touch on testamentary trusts now because it's very important. People have probably heard about testamentary trusts and how they protect your estate, protect your inheritance for your children, for instance. It's very important to know that testamentary trust won't do anything to protect against a family provision application. So that's why I'm going to talk about testamentary trust now, because I wanted to lead into that, because a lot of people have this false idea that if they have a testamentary trust, then it's going to stop someone making a claim against their estate. That's not the protection aspect of a testamentary trust. Testamentary trusts are protective, but it's only for your beneficiaries in the future. So let's say you were to pass away and leave $500,000 in a testamentary trust for one of your children. If that children then gets divorced years later, then the money that's in their testamentary trust won't be considered theirs, provided it can be taken control of by an independent person. And then it won't form part of their property pool in those family court proceedings. So in that way, it protects your child's inheritance or your beneficiary's inheritance from people that are trying to attack your beneficiaries, but it doesn't protect people who are trying to attack your estate. That's not something that testamentary trusts do. So I'll speak a little more about testamentary trusts now. So essentially what they are is a separate entity that holds the inheritance you want to give to your children, as opposed to giving it to them in their individual name. So in a standard will, your assets will pass directly to your individual beneficiaries. It will go into their name. And then if they get divorced, go bankrupt, or get sued, anything you've given to them has the potential to be given to those third parties who are trying to attack them. If you have it in a testamentary trust that has a protective mechanism that allows someone independent to step in, should those events occur, then those assets will be protected against those third-party attackers. That's one of the main reasons people like testamentary trusts, is because they don't like the idea of their inheritance going to a future ex-spouse, for instance, of one of their children, a future in-law, ex-in-law, for instance. The other good aspect about testamentary trusts is the tax minimisation. So the way they work is it's a trust, so it's a discretionary trust, and the trustee decides how to distribute the money and the income that the trust makes. So if you have $500,000 in a testamentary trust and it's making income from the investments that it has each year, your beneficiary can split the income that the trust makes amongst that person's family. And if they have minor children of the age of 18, they can give that child 18 grand tax-free each year from the testamentary trust for their expenses, such as school fees and things like that. So that can work out to be quite a large tax write-off. If you give it to beneficiaries that have minor children, they can be very effective.
I'll just jump in there, Tim, just to elaborate on your point there. So if you were to give money, let's say to children or grandchildren, etc., and they had, for example, let's say $500,000 in your example, but they earn income on that in their own name, right? Minors can only earn up to $416 effectively tax-free. Anything over that effectively gets taxed at the top marginal tax rate, where if you held it in this testamentary trust, as Tim mentioned, it could stream to minors, which are kids under 18, up to $18,000 or $20,000 tax-free. So that's the tax benefit of utilising a testamentary trust.
Yeah, that's right. And it's important to note that that's only for assets that pass through an estate. So any assets that you have in your estate, in your personal name when you die, can pass through a testamentary trust and then gain those benefits for those minors, the tax benefits to go into those minors. If you set up a testamentary trust for your beneficiary and then that beneficiary puts money into that testamentary trust, then the money that is placed into the testamentary trust after death will not gain those benefits. So that's why it's important with testamentary trust, and most of the time, you want to put assets into your estate so that they go through the testamentary trust and gain the benefits, as opposed to if you're worried about someone claiming your estate, you want to get assets out of your estate. Yeah. So it's a catch-22. If you have a testamentary trust, but you're worried about people claiming your estate, estate, it can be very difficult to decide on where you think the money should go upon your death.
Got a question, Tim. The beneficiaries of the will, and who, obviously if they set up a testamentary trust, they have the option to utilize testamentary trust. Is that right?
Yeah, they do. So any testamentary trust that you put in your will these days, my wills anyway, and I would say that most wills, testamentary trust wills out there, do give you the option these days. So essentially, if a beneficiary is to receive a certain amount of money into a testamentary trust, they have the option of asking the executor to say, no, can I please have that money put straight to me individually? I don't think it's worth having the trust at this point in my life. Now, my wills would only allow someone to do that if they were over the age that you stipulated, which is normally about 25, because you don't think that a child would be old enough before that time. So most of the time, there's not going to be a very good reason to elect out of a testamentary trust unless there's just not enough money to make it worth it. Or if you're a foreign beneficiary, for instance, and it's a testamentary trust isn't going to be cost effective because you are foreign, then it might be worth not having the testamentary trust as well at that point. And then lastly, I just want to touch on enduring powers of attorney. So these are documents where you're appointing other people to make decisions on your behalf if you do not have capacity to make decisions for yourself. So main reasons that you would want one of these in place would be if you are ill, if you're in an accident, or if you have dementia later down the track. So why these documents are important? Most of the time, you're probably not going to need these documents until much later on in life. But if you do need one, it's the sort of document that your family members really will wish you had. If you don't have an enduring power of attorney, then no one will have authority to deal with your assets or your bank accounts or your property or your insurances. So if those decisions do need to be made and you have lost capacity, someone needs to apply to a place called QCAT, Queensland Civil Administration Tribunal, to be appointed as the person to deal with you and your assets. So that's not something you want to put your family members through. So it is always better to have these documents in place. They're not very difficult to get done, and they are definitely worth it when you need it.
Just got a question. Oh, sorry, a comment to make about enduring power of attorney. So also I forgot to mention, guys, if you've got any questions, down the bottom there's a Q&A button. Just type your questions in, and we'll hopefully answer them at the end. But just with an enduring power of attorney, obviously we're going to ask the clients with self-managed super funds. And one of the things with a self-managed super fund is if you do lose capacity, then potentially you need to wind up your portion of your self-managed super fund. However, it does sort of stipulate in the regulations that if you do have an enduring power of attorney, you can appoint your enduring power of attorney to manage your self-managed super fund, or at least your benefits. So it's important that you do actually have an enduring power of attorney if you do have a self-managed super fund.
Right. And you would need to stipulate that in the document that you do, the enduring power of attorney, that you are giving them power to act for your super.
Yeah. That'd be under the financial decision.
Yeah, the instructions. Yeah. That if you are an attorney acting for someone who's lost capacity and managing their super, you do need to be careful, because you need to keep in mind, you need to act in the person who's lost capacity, their best interest. So if you're removing super, for instance, to pay for them, you need to keep in mind, if they wake up, if they gain capacity, would it have been better for them to have kept the super in there so that they can use it later on in life? So also, if you're taking super out, then you may be disadvantaging people that were to receive that super later on after death. So there's a few issues involved with there. If you are acting as an attorney and you are dealing with super, I would recommend that you seek legal advice. I just wanted to touch on updating enduring powers of attorney. Really, it's fairly similar with your will. If you have an enduring power of attorney in place, you should make sure you look at it every 3 years. And if you have married or divorced, it's going to be a good idea to get that updated pretty immediately or separated again, which is the most important time really to update your documents. And obviously, if your attorney dies or loses capacity themselves, then you're going to need to renew your documents as well. So that's pretty much all I wanted to go through today, Lee.
I've just got a couple of questions as well, just to sort of finish up here. Trusts. We've got a number of clients that have got, family trusts, etc. How does that kind of get sort of wrapped up into your estate or whatever? I think it obviously sits outside, but how does that get dealt with? Like, let's say that, you're the appointer, etc. How does that?
That's right. So your trust is a separate entity, and the assets that are in the trust won't actually form part of your estate upon your death. So if you control the trust, then you can pass over control of that trust through your will normally, or the trustee will allow you to do it automatically to someone, might appoint someone as an alternate appointer. So that role of appointer or principal, it's normally called, is the person that essentially has control of the trust. So they can hire and fire the trustees, who are the people who control the day-to-day management of the trust. So in your will, if you do have a discretionary trust or a unit trust, we will normally put in a clause that says, I pass over control of my trust that I control at the time of my death to my spouse or children, however you want to do it. But it is important to note that any assets in that trust will be kept in that trust upon your death. They are not estate assets. And trust can be effective to protect against family provision applications. So if you have assets in a trust, they won't become part of your estate and hence won't be claimable by someone making an FPA, a family provision application, against your estate.
Cool. And just obviously we touched on before about blended families. Obviously it's becoming more and more common these days. What kind of advice do you give sort of blended families when constructing their estate planning needs?
Well, seek advice.
Situation, right?
Yeah, that's right. So very important to speak to a lawyer, because you probably haven't thought about the issues and you probably haven't considered the amount of people that can make a claim against your estate. So you really need to think about whether or not the people like your children or your stepchildren are inclined to make a claim, are inclined to be upset at the way you are distributing your estate. It's always a good idea to be open about it, in my opinion, unless you're leaving someone out completely. It's a good idea to tell them what your intentions are so that they're not surprised. Because if someone dies and then their child finds out they were left nothing and everything went to their stepmother, for instance, you're going to cause conflict straight away. So the best advice would be to make sure you have the discussions with the people that you do care about and make sure that they're okay with the situation, or at least for now. But yeah, case by case, it really depends on your situation, what you have, and who you're leaving it to.
Okay.
I see there's
a question. So someone's just saying, can they get a copy of the your slides?
Yeah, absolutely. I'm happy to email the slides, definitely.
Cool. All right. Well, you can flick them on to me, and then I'm happy to sort of pass them out. But look, thank you very much for everyone attending today. I think that was absolutely fantastic. Tim, thank you very much for your time. I've learned a couple of things today that I didn't know about, but obviously it's very important that your estate planning is considered and reviewed on a regular basis. I've got Tim's details. If anyone wants to speak to Tim or myself, I'm happy to pass on Tim's details. But thank you very much for attending, and Tim, thank you very much for your time today.
Thanks very much for having me, Lee, and thanks everyone for tuning in. It's been very enjoyable telling you about what I like to do. So thanks very much.
Appreciate it, Tim.
Thanks, Lee.
Thanks, mate. Thank you, everyone.